This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about the need for an insurer who has insured a person against liability to third parties to select and work with counsel. In instances where insurance claims may entail litigation, insurers must move quickly to engage competent counsel to represent their insured. When an attorney is retained to defend a person insured, the facts should be documented in writing by the attorney, the adjuster, and the insured who is to be defended. Before an insurer retains an attorney to represent an insured to defend the insured who has been sued for a tort, the claims person should be certain that the lawyer is competent to defend the insured. This can be accomplished by attending a trial conducted by the lawyer, where the claims person can evaluate the lawyer's competence at trial, if that option is not available. And the adjuster must understand that very few cases actually go to trial. The claims person should seek recommendations from other insurance claims professionals who have retained the lawyer in the past, or the insurance company's list of approved defense lawyers who have been evaluated by the insurer's management. If the attorney is to be retained for the first time by the insurer should obtain an engagement letter from the attorney, setting forth the terms and conditions of the retention, and signed by the attorney, the claims person, and the insured. If the attorney or law firm representing the insured has an ongoing relationship with the insurer, only the person being defended needs sign an engagement letter. The engagement letter should at least list the following details: the effective date of the agreement, the fees to be charged, the units by which fees are calculated, usually in 6-minute increments or tenths of an hour, and a representation as to how often the attorney will submit fee bills, usually monthly or quarterly, a description of reasons for discharge and withdrawal or conclusion of services, a disclaimer of guarantee. It should also outline the scope of the engagement. That is, it will specify that counsel will review copies of contracts and insurance-related documents he or she has been provided, review the files of the insurance broker and/or the underwriting files of the insurer, attend, take, review, and analyze the depositions of the plaintiff and defendant, experts and factual witnesses, as well as any other depositions agreed to be reasonably necessary. Review any other files or documents that counsel, the claims person, and the insured defendant deem necessary. These might include those of plaintiffs and defendants, as well as others who might have facts relevant to the defense of the case. To review all pleadings and discovery that he or she, as well as the claims person and the defendant, deem necessary to present a competent defense. Provide his or her opinion regularly as the case progresses, and respond to inquiries from the claims person and the insured defendant. Consult regularly with the insured defendant and the claims person on various issues related to the case. Prepare regular reports to the insured defendant and the claims person. With the approval of the claims person, file necessary motions to the court, including a motion for summary judgment. If appropriate, attend mediation or settlement conferences with the insured defendant and claims person after providing the insured and the claims person with opinions on the settlement value of the case. And if all attempts at settlement fail, present evidence at trial and defend the insured through trial and any necessary appeals. At retention, the claims person should, in writing, instruct the counsel on the following matters. 1. The basic facts of the case learned in the initial investigation. 2. A brief description of the documents collected by the adjuster. 3. A statement of the date and time the summons and complaint were served on the insured. 4. A summary of the coverage and limits available to the insured. 5. Transcriptions of all recorded statements taken by the adjuster. 6. The insurer's requirements regarding billing by counsel. 7. The insurer's requirements regarding reporting from counsel concerning the litigation. 7. The insurer's requirements concerning work to be done by counsel, partners, associates, and paralegals. And 8. The insurer's requirements concerning limitations, discovery, and motion practice based upon approval of the insurer. The adjuster should provide the attorney with as many original documents as possible and keep copies for his or her own files. The claims person must understand that all documents collected by the adjuster are important to the defense. This includes the service copy of the summons and complaint. The adjuster must advise the attorney of the exact date and time the complaint was served on the insured to ensure that a timely response is filed to prevent the entry of a default. In most states, a defendant has 30 days from the date the complaint is served to file a formal response, and 20 days in most federal courts. Failure to formally respond to the complaint or obtain an extension of time to respond allows the plaintiff to declare the defendant in default and seek judgment as if the defendant had admitted all of the allegations in the complaint. Once a default has been entered, a judgment against the insured will follow unless good cause can be shown why the default should be set aside. Adjusters should make every effort to avoid putting an insured into such a difficult position by retaining competent counsel promptly. The insured must also report service of a lawsuit immediately with advice as to the time and place the summons was served, the person who received the summons, and the reason for any delay in delivery to the insurer. The defense attorney should also have available 1. A specimen copy of the policy, 2. A complete copy of the claim file, and 3. A copy of the insurer's policy, if any, with regard to billing and case handling. If the insurer's billing and case handling practices are not available in written form, the initial retention letter should describe them, or it should be attached as an exhibit. The claims person must understand that an engagement letter is an effective contract between the lawyer and the insurer. As a matter of law, there could not have been an implied contract. Personally, because the court has decided the implied contract issue as a matter of law based on undisputed facts, the issue of whether there is a factual dispute regarding the existence of an implied contract would be moot. Like an insurance policy, a lawyer's engagement letter will be read as written if there is no ambiguity. When the language of the engagement letter is clear and unambiguous that defendant agreed to pay plaintiffs 5% of the gross income received by defendant less any amounts clearly defined as reimbursements of your expenses, and defendant came forward with no evidence that any portion of the 4 installments, totaling $1,055,000, that she receive represented reimbursements for her expenses, the contract provided that the fee paid defendant was inclusive of all and any personal and or business expenses incurred by the defendant. This is Krause versus Kaufman, a 2013 decision of the New York Appellate Courts. In a situation where there is no dispute that the parties entered into an enforceable fee agreement, the terms of which were set forth in the engagement letter, a court will enforce the agreement. When the defendant responded to requests for admission in which she acknowledged signing the engagement letter, receiving itemized invoices for services rendered under the engagement letter, and paying some of the fees and expenses charged by the lawyers, the fees must be paid. The adjuster and the attorney should meet in person to reach an agreement that they will work as a team in handling the case through trial, and that they are both in agreement with the terms and conditions of the lawyer's engagement letter. Whenever an insured is sued and requires a defense, or the insurer is sued, the insurance adjuster and the defense attorney must understand their respective roles in preparing the case for trial. They must develop a rapport with each other and with the insured person or entity that is being defended to make communication easier to maintain. Bad faith lawsuits and poorly tried bodily injury cases seem to arise only when the adjuster and the defense attorney fail to communicate regularly with each other and the policyholder. At the first meeting, the attorney and the adjuster should agree on the division of labor with regard to the preparation of the case according to their respective training and experience. Counsel and the claims person should reach an agreement regarding the handling of the case. Claims adjusters often mistakenly leave all investigation tasks to the attorney. Most adjusters are also investigators and are trained to fulfill the duties of an investigator within the narrow field of expertise of an insurance adjuster. Therefore, the adjuster should do as many informal interviews of witnesses and parties as possible and provide the results to the attorney. The attorney should limit his or her investigation work to the preparation of witnesses before the trial or deposition. Work that was usually done by an attorney or by a legal assistant would include meeting with the insured defendant to obtain facts for answering interrogatories, interviewing the insured and key witnesses, including getting recorded statements from each, collecting and preparing documentary evidence such as medical records, police reports, and employment records, preparing pleadings to lawsuits such as answers and motions, preparing for and taking depositions of parties including plaintiff or defendant and independent witnesses, preparing written discovery such as interrogatories, requests for admissions, and requests for production of documents, preparing, filing, and arguing motions with the court, preparing mediation briefs, attending and negotiating potential settlement at mediation or court-ordered settlement conferences, preparing motions in limine before trial, preparing trial briefs for presentation to the court before trial begins, preparing evidence and witnesses for trial, and presenting evidence and arguing legal issues at trial. This is the beginning of every liability insurance claim that goes to litigation. It is the obligation of the claims person to hire a defense counsel to work with the insured in presenting a defense to the case. that defense counsel is controlled by the insurer, but his or her duty is only strictly to the defense of the insured, even if the defense of the insured requires that counsel do something that would be detrimental to the rights of the insurer. And it is the obligation of the insurer to so advise defense counsel that their obligation and duty is to the insured, and that their obligation to the insurer is to advise and counsel with regard to the defense of the insured and the value of the case as a settlement if the insured is liable to the third party. This video was adapted from my book, Zelma on Insurance Claims, Part 108, Second Edition, which is one of a 10-part treatise called Zelma on Insurance Claims, all of which are available from Amazon.com as Kindle books and as paperbacks. If you found this video to be interesting or of use to you or your colleagues, please forward it on. It's free. And please subscribe to my Rumble channel, my YouTube channel, and my blog so that you can be advised of future videos and future blog postings. Thank you for your attention.